Hey, everybody. Welcome to True Crime Wednesday. I'm Lori Hellis. I am a retired criminal attorney who wrote the book about Lori Vallow. Um, and we have Vallow news tonight. So, welcome, everybody. She is, as we speak, going to start trial, her last of 4 trials for well, 3 technically, because wasn't in Chad's trial, but her last of 3 trials, in the attempted, um, unfortunate unaliving, as, Kathy from Rumor and Innuendo says, Gossip, Rumor, and Innuendo is her channel, and, the attempted murder of Brandon Boudreaux. Brandon was the husband of Melanie Boudreaux, who is Lori's niece, the daughter of her deceased sister, Stacy. And Melanie had been like another daughter to Lori for a long time. So at Lori's, under Lori's encouragement, she divorced her husband, Brandon Boudreaux. After the divorce was final, but before Brandon had actually changed his life insurance, Lori and Alex Cox, allegedly at this point, conspired to murder Brandon for the life insurance. Charles Vallow was already deceased. He was murdered in July. The children had already been moved to Rexburg, and in fact, they were already dead as well. This happened in early October, about 10 days before Tammy Daybell died. Alex Cox drove from Rexburg to the Phoenix area to Gilbert, Arizona, and waited outside of Brandon's home. Brandon had only recently moved from the family home into a rental house, and there were only 4 people who knew the new address. One of those, because they had joint children, was Melanie. The only person who knew Alex Cox was Melanie. It's pretty clear how Alex got the address and sat in waiting for Brandon. Brandon dropped his children off at daycare, went to the gym, and when he came back in, strangely parallel to Danny Markell in the Adelson case, pulled back in the driveway, and Alex Cox took a shot at him. Fortunately, Alex wasn't that great in aim and missed. Alex then sped away, and Brandon reported it to the police. Now, Alex Cox is dead. He died in December of that same year of 2019, and the coroner ruled it natural causes, although lots of people have had lots of suspicion that it may have been an intentional act on his part. So Lori is waiting for trial. As you might all recall, she stood trial in Idaho, was convicted, and went to state prison. The Arizona district attorney had held their charges while she was prosecuted in Idaho. But once she was convicted in Idaho, then they asked for her to be extradited. So she was extradited to Arizona a little more than a year ago, I believe, and has been working through the system there. She continues to demand her speedy trial. The judge, over her objection, continued the case because legal counsel wasn't ready, and then she decided to represent herself. So she has been representing herself both in the last trial in the murder of Charles Vallow, her fourth husband, along with her brother Alex, who actually pulled the trigger, and this case against for Brandon Boudreaux. So she the trial was supposed to start late last week. She came to court and told the judge that she was ill. And the judge then said, well, we won't start picking a jury until Monday. She showed up on Monday in the courtroom in her civilian clothes, but in a wheelchair, and claimed that she was too sick to go forward. So the judge ordered the jail to assess her physical condition and postponed until today. So from Monday till today. And this morning, she didn't want to come to court. She said she was still sick. The judge then issued an order and said, you will be here either by force or willingly. And so she willingly showed up in court. She came in sort of hunched over and sort of acting like she was very frail, and she sat down at the table, and she talked like she was really not feeling well. And the judge, the jail sent their lawyer, who came and told the court that Lori had been assessed, and although they did diagnose something, it was not anything contagious or anything that they believe should keep her from coming to court. They did have a sidebar where the judge sort of reviewed that information privately because it is medical information. And the judge found that there was no reason for her not to go forward. So they went forward with jury selection. She did participate and did ask questions. Those who were in the courtroom said she seemed to get a little stronger and maybe forget she was sick as time went along. And they actually did seat a jury. So the jury is in place, and they're going to start opening statements tomorrow. So I'm going to be juggling a little bit because I am also following Karen Reed. So I'll be trying to keep up with both of those tomorrow. Fortunately, Karen Reed is off tomorrow. We'll get to Karen Reed in a minute. But I did want to talk really quickly about Donna Adelson, because there's been some kind of interesting developments in Donna Adelson. So you might recall that not too long ago, maybe a couple weeks ago, it came out, well, actually it was just before her trial was supposed to start. It came out that the prosecutor had new information, and that they had provided that new information to the defense, and it was voluminous. And so the defense went to the judge and said, we just got this great big dump of all this new information, and we need more time. So as it turns out, what has been going on is that, of course, Donna has been continuing to talk to people on the telephone, including talking to Harvey, including trying to use other inmates' ID numbers so that her calls aren't recorded. And potentially, and this is not anything that is proven, so I don't want to put misinformation out there, but the state alleged that some of the phone calls that were placed to Harvey were placed from Donna's lawyer's phones at the time that they were in the jail visiting Donna. So the state alleged, that there was probable cause to believe that Donna's lawyers were supplying her with a telephone to talk to Harvey on an unrecorded line. They used that information to get a tap on Harvey's phone and turned up some troubling information. Um, so there's several issues that have come up. One is that the prosecutor went to the current judge and said to the judge, "Judge, we have probable cause to believe that Donna Adelson's lawyers are illegally, because it is against the law to take an inmate a phone, to introduce contraband into the jail. Um, we have reason to believe that her lawyers are allowing her to use their telephone, and that's why we want a tap on uh, Harvey's phone." So the tap on Harvey's phone was approved, but it gave the judge information that could prejudice him or prejudice his opinion. Now, we do not know whether these allegations are true. And in fact, Donna's attorneys have vehemently denied it. So nobody's seen the proof, so nobody really knows. But that led the defense to very promptly file a motion to recuse the judge, who has been the judge on all the trials, and his name escapes me right now. I'm sure somebody will stick it in the chat. But um, so that's what's been going on with Donna. And so the judge said, because even before this all came out, the judge said, "You're right, you just got all of these emails, and she's supposed to be starting trial," and he bumped the trial out until the end of August. So that happened. N- Judge Everett. Thank you, Rachel. Um, so Rachel's like my alternate moderator. She's always the one with all the answers. Um, so anyway, they they filed a motion to recuse Judge Everett, saying that this information that was presented to him in order to get the warrant for the tap on Harvey's phone means that he can't be fair. I mean, this has tainted his understanding of the parties, and it's possible he could be prejudiced. So he denied the motion to recuse himself, and it went up to a three-judge panel at the at the Florida Supreme Court. So the way most Supreme Courts in states work is you file an appeal, and it goes first of all to a panel of the judges that are on the court. So not all the judges hear every case. So a three-judge panel reviews it. And then if the three-judge panel denies the hearing the case, then you can ask for the entire, what they call en banc, ENBANC, more Latin. It means the whole panel. And so they requested that it be reviewed for an en banc hearing. That hasn't been decided yet. And that has to do with Judge Everett and whether or not he can continue to stay on the case. Now, if they were to find that Judge Everett can't stay on the case, that doesn't mean that the case gets postponed. There's still plenty of time until the middle of August. I think it's August 19th. There's still plenty of time between now and August 19th for a judge to get up to speed and be able to hear any pretrial motions. So we're just sort of waiting to see what the ruling is going to be on that. I suspect that the court is not going to recuse Judge Everett. So here's the thing. there's a difference between I don't want I don't want anyone to hear anything prejudicial against my client, and I don't want a jury to hear unduly prejudicial information, because by its nature, a prosecution is prejudicial against a defendant. The evidence is going to come in is going to be that the defendant committed a crime, and clearly that's going to be prejudicial to that person's rights. The question is it more prejudicial than probative, right? It, is it so prejudicial that its value to prove the crime out is outweighed? So in this case, I suspect that the Supreme Court is going to decline to hear it, and I suspect that Judge Everett is going to continue on the case. That is not going to make her or her lawyers very happy. But this isn't over, because there's still an investigation into whether or not her lawyers committed crimes, broke the law. And if it can be proven that that is in fact what happened, then there's a way bigger issue going on. And if her lawyers are accused of crimes related to the case, which we saw in the Melly case, uh, then this case could get delayed a lot longer while she gets yet again another set of lawyers. Remember, she had Rashbaum. Um, Even though she waived conflict because he'd previously represented her son Charlie, Charlie didn't sign the waiver, and so Rashbaum was forced to withdraw. Rashbaum and his whole team. So she had to get a whole new team of lawyers, which is why it's taken so long to get her to trial. Now, if her lawyers get uh, charged, they're going to have to be removed, and she's going to have to get another set of lawyers. So there's still a lot to be determined, TBD, on Donna and how that case is going to go. I'd say maybe 50-50 that she goes in August. A lot of it is going to depend on the outcome of this ongoing investigation into her lawyers. So remember in the Y&W Melly case, um, uh, Jamal Demons is his name. That's a Florida case as well, and that was a case where the prosecution claimed that one of his lawyers, her name is Raven, I don't remember the last name, but one of her lawyers had conspired with him to tamper with evidence, to tamper with jurors and or witness tampering, and the uncomfortable part about that is that they have never brought charges against that attorney. They just keep it's like hanging over everyone's head. So his trial got delayed because he had to decide whether in the face of this stuff hanging over them, if he wanted to continue with her, which he did decide to continue with her. Um, so, and that one, he's been in custody now like almost 6 years. His first trial ended in a hung jury, and it's taken forever. The prosecutor was accused of misconduct and had to be removed for lying to get evidence. I mean, that was mess. So it really isn't a big surprise, since we're dealing with another Florida case, that kind of stuff's going on. So I told you all about Lori. So I guess we're ready to jump into Reed. Holy cow. Reed got juicy this last week. The defense started their case, and they came out swinging. If you remember, the prosecution finished their case with Shannon Burgess, who was who talked to them about gathering all the data from the car's infotainment system. And then they finished with Dr. Welcher, who was their expert on all of that digital information. So, and if you'll recall, Shannon Burgess was discredited really early because he's lied on his resume about his education, and that's just pure stupidity if you're going to be testifying in court. I mean, no one said he had to have a bachelor's degree or he couldn't do this work. The problem is that he lied about having a bachelor's degree, and that's something you absolutely don't want to do, because if you get caught in a lie, there is a jury instruction that is given to every jury, and in a lot of jurisdictions it's titled witness faults in part. What that means is, what the instruction says is, if you as a juror find that this person has lied on the stand, you can discount all of their testimony. You can presume that if they lied about one thing, they are lying about everything. You as a juror can choose what to believe and what not to believe. And if you believe that this person, this witness, is a liar, you can completely discount all of their testimony. So it is so dangerous for a witness to come out and do something that stupid. Well, Dr. Welcher didn't fare much better. Robert Alessi has been their go-to for crossing experts, and he's like a machine. I mean, he is amazing. Um, Melanie Little calls him Alessi Scissorhands. I mean, he's something else. He doesn't miss a thing. And here's the thing about lawyers. A lot of us became lawyers because we couldn't do math. We couldn't be doctors because we couldn't do math. And so a lot of lawyers are not the best at scientific information. Occasionally, you get somebody like one of my friends who I practiced with here in Central Oregon, who was a former patent lawyer and a former engineer, and he's like Bob Alessi. Bob Alessi is also a pharmacist, so he's got a science background. And he really understands this stuff. He can get in the weeds. He understands excuse me, the formulas, and really I mean, he's the guy who can check everybody's math. So that's exactly what he was doing with both Shannon Burgess. Now, he went after Shannon Burgess for lying on the stand, and that sort of was the beginning of the end for him. But he really went after Dr. Welcher for his process and his methodology. And really, I will say about Alessi is he's pretty good at being able to put it in terms that the jury is going to understand, even though he's dealing with really complex scientific concepts. He's able to put it in terms that the jury understands, and that's huge. So it's sort of like us law tubers coming on and explaining the legal world in ways that non-lawyers can understand. So Alessi's doing the same thing. He's using his expertise both as a lawyer and as a scientist to be able to put it in the terms that the average juror is going to understand. It not that jurors are dumb. I mean, we get you get a cross section of jurors. You can get doctors and scientists and those sorts of folks on juries too. But you can't be guaranteed that you're going to get someone on the jury who's going to understand these concepts and be able to explain them to your fellow jurors. So it's great to have somebody like Alessi there because he's sort of got a real unique skill set. And he's very good at being able to uh, being able to put complex scientific concepts in simpler and more understandable terms. So the very first witness out of the box after Alessi crossed both Burgess and Welcher, the very first witness out of the box was Matthew DeSogra. And I thought it was very interesting that he was very much a contrast. And I think you're going to see this with the crash daddies, with the ARCA experts as well. There's a very big contrast between the defense experts and the Commonwealth experts. And unlike Burgess, who was clearly unqualified, and unlike Welcher, who was qualified but was also very combative. I mean, he was such a difficult witness, and it just sent such a bad message to the jury because he was just so he was ready to fight over every word. I mean, so it was interesting because Matthew DeSogra is really sort of the antithesis of that. Very calm, very soft-spoken, very easygoing, answered all the questions, but very confident about what he did. So what they had him do was they had him take the data that was recovered from uh, from the Lexus, Karen Reed's Lexus, the infotainment system and the black boxes and all that. So they had him not go out and reinvent the wheel, retrace all of that, retrieve all of that data. What they said to him was, we want you using the same data that Shannon Burgess and Dr. Welcher used. We want you to analyze their conclusions and their methodology. So he did. He was very easy, and Alan Jackson did this direct examination. It wasn't Alessi. And he was very good at going through and showing his work, and in a very understandable way. He wasn't talking about formulas and algebra, and he was doing this in a very straightforward way. So he went through and he looked at the entire universe of possible ways to calculate the time. So one of the critical timing issues is we know that there was a triggering event, they call it. It was not a collision. It did not register in the car's collision or pre-collision software as a collision, but there was some sort of triggering event, as they call it, and that can be quick acceleration or quick braking, or it could be a number of things. It's not a collision. But they believe that that triggering event is the event that ended John O'Keefe's life. So the other piece of data is that when they extracted John O'Keefe's phone, they found out that John O'Keefe manually pushed the lock button on his phone just before he died. So this Commonwealth has been trying to line those two things up so that he pushes the lock button before the event happens. Because if he pushes the lock button after the event happens, it couldn't have been what caused his death. Hopefully that makes sense, because the timeline doesn't work. Because the medical examiner, and I know we're probably going to hear from the neurology medical examiner. That's another piece. But the medical examiner basically testified that after the injury to the back of John O'Keefe's head, he would not have been able to do anything. He would have been completely incapacitated almost immediately. So there's knowing that, they know that if this triggering event is actually the event that's responsible for John O'Keefe's death, he has to have locked his phone manually before that event happened. So the prosecution experts have been kind of monkeying around with that timeline for a while. And in fact, Shannon Burgess, the discredited Commonwealth expert, filed a supplemental or updated report after the trial started to try and square his data with Dr. Welcher's timeline. And that was the whole purpose of that. The defense complained about it, and the judge let it in anyway. Don't get me started on Judge Cannoni. So the judge let it in. So Matthew DeSogra's, the purpose of his testimony was to look at the entire universe of possibilities for that phone. So he looked at factoring in the fact that the infotainment system doesn't start to register until 3 seconds after the car starts. And I mean, he factored in every one of these what ifs. And so he took 30 different possible scenarios and did the math and the timelines on them. Out of those 30 scenarios, he could only create 3 where John O'Keefe's, that lock on John O'Keefe's phone doesn't happen after that triggering event. And in 2 of those, he could narrow it down to make them simultaneous. So there was actually only 1 out of 30 that he could say could have happened. One of the 30 different ways it could have happened that actually would have John O'Keefe locking the phone and then the event happening. So it was very persuasive testimony. And Hank Brennan tried to rattle him, tried to go after him. And all Hank Brennan did was make himself look really bad, because Matthew DeSogra was very poised, very confident in what he was saying, and very calm, very and the calmer he stayed, the more agitated Hank Brennan got, and the more he started clapping back. And he made himself look pretty unprofessional, and yeah, I don't think he did himself any favors. His cross was pretty ineffective. one of the things that Matthew DeSogra said was, so Hank Brennan said, well, yes, but Matthew DeSogra, he found the data on the chip that nobody else looked for, so he's the hero here. Matthew DeSogra said, well, maybe, but he didn't follow his own protocol. He went rogue, and that's how he found that chip. And I'm not so sure, because the reason he was looking for that chip wasn't because he thought there was information on it that was going to be crucial to the timeline. He was looking at it because he was convinced that the chips that he had didn't have all the data on them. The reason is because he mixed up bits and bytes. I'm not a computer expert, but I know that bits are much smaller than bytes, that bytes are made up of lots of bits. And he mixed that up. So when he was looking at the capacity of the chips, thought that there should be a whole lot more data on them than there was, because he was mixing up bits and bytes. So when he went rogue and decided to start pulling chips out of the panel that he had not previously planned to do, it wasn't because he was looking for something that he thought was there. He was convinced that they didn't have all the data, because there should be more. So of course, Burgess had already gotten skewered on Cross for lying about his education. Welcher came across as so combative and such an advocate for the Commonwealth that I'm pretty sure the jury found that really hard to swallow. So when DeSogra was done, then the next person they brought in was Jonathan Diamandis. Now, toward the end of the day, after DeSogra had been on the stand, the judge sent the jury home, and then took up this issue of whether Jonathan Diamandis could testify. So here's who this guy is. You probably remember at the last trial that some very distasteful and disgusting text messages came in that had been sent by Michael Proctor, who was the lead investigator from the Massachusetts State Police. Michael Proctor has since been fired from the Massachusetts State Police as a result of his conduct on this case. One of their findings was that he was fired for being biased. So not only for these really disgusting text messages, a lot of them about Karen Reed, but also because he was clearly biased against the defendant. So there are quite a few reasons why nobody wants to bring Proctor in. Everybody's sort of treating him like he's radioactive. The state didn't want to bring him in because they would have to put him forward as a credible witness, and yet he would be discredited, and they don't want to bring him in with all that baggage. The prosecution doesn't want him, or the defense doesn't want him in, if they can get that information in a different way, because then they open the door for the Commonwealth to rehabilitate Proctor, and they don't want to do that. Because him looming out there, they can argue that Proctor was just a piece of a much bigger puzzle of corruption that was going on in the Canton Police Department, the Boston Police Department, and of course, the Massachusetts State Police. It's much easier to paint him as a boogeyman than it is to have him on the stand and let the Commonwealth try and rehabilitate him. So they would much rather not call him either. So they filed a motion with the court for the court to allow the text messages in by having them authenticated by somebody else that was in that text group and on that text stream. So this was a win for the defense. I think, I don't think that Judge Cannoni is any friend of the defense. And I think that the only time she rules in their favor is really when she doesn't have a choice. The law is so clear that there's no way around it. So typically, the Commonwealth argued this is all hearsay. It's an out-of-court statement. There's nobody here to testify to it, and it should stay out. But there are many exceptions to the hearsay rule, and one of them is the biggest one is if it's not coming in to prove what that information says. So these text messages are not coming in to prove that Karen Reed is guilty or that she's a C word or that the Boston cop whose house it is isn't going to catch any grief. None of these text messages are being offered to prove the contents of those text messages. They are being offered to show Proctor's bias, and motive and bias are two things that are exceptions to the hearsay rule. So the defense said, Judge, we're not bringing these in to show that any of these things are true. We're bringing them in to show that Proctor is biased and that he was biased against Karen Reed. And the judge had to agree that they came in. But she did require that they do a voir dire or different jurisdictions call it something different. Where I'm from, we call it a proffer, an offer of proof. It's kind of like a portmanteau, a proffer. And when you proffer a witness, you do that outside the presence of the jury, the way they did before DeMontis testified. So these names are all starting to run together, I'm telling you. So the judge turned the jury loose and then did the voir dire or the proffer. And once that was done, she said, I'll give you my decision tomorrow. So both he and there was a police officer that was there that was a potential witness. And the judge called her up because she had to, on the record, tell her that she needed to come back tomorrow because she needed that for her employer. So the judge did those things off the record and then said, I will give you my decision tomorrow. So the next morning, she came in and said, I'm going to allow this person to present these text messages. So the guy came in. He seems like a nice guy. And so they swore him in. It was very clear that he didn't want to be there. He didn't want to be doing that. He said he's still friends with Proctor, that he understands that Proctor was fired for his conduct on this case and in some part for these text messages. But he clearly didn't want to be there. But he was very cooperative. He was very polite to both sides. So so the next thing that happened was the defense got up asked him to authenticate those text messages, that they were in fact text messages, that he was one of the recipients, that they did in fact come from Michael Proctor, and that what he was looking at was a true uh, copy of those text messages. So the authentication was done, and then the defense simply took the exhibit and said, we want to offer this into evidence. The judge put it into evidence, and they said, we're going to send this with the jury for them to review. Well, Brennan, for some reason, decided that that wasn't enough, and he got up on cross and had this guy insisted that this guy was going to read all of those text messages. So they got to the first one, and the guy looked up and he said, I am not comfortable reading these messages. They are not my messages, and I don't like having to read them. So then there was a sidebar. And when they came back, what they agreed upon was that Hank Brennan would read the text of the messages, and then the witness would confirm that that was what the message said, and that that was a message that was received on the text stream. However, Brennan insisted on, in open court, once again putting those messages out into the ether. Additionally, there were messages that were that we didn't hear in the first trial that were offered in this trial. And in one case, a really unfortunate one, having to do with John O'Keefe and his niece and his nephew. And I don't believe that it was information that was previously public. I'm not going to repeat it because I just don't think it's right. It's information that doesn't have any real bearing on the case, and it was cruel of Hank Brennan to make it public. Those children have been through enough. Their mother has died, their father has died, and their guardian has died, and they have enough grief. So it was, in my opinion, pretty unconscionable of Brennan to do that. And it certainly wasn't something the defense wanted to do. They, in fact, were satisfied with just giving a copy, pages of the printed text messages to the jury and having the jury review them on their own. So that was pretty awful. He seemed, like I say, Jonathan Diamandis seemed like a nice guy. He said he's known Proctor since they were kids. The guys on this text stream, I think we heard that in the last trial as well. The guys on this text stream, some of them have been friends since elementary school. They all grew up in the same neighborhood. And so I don't think, I certainly don't think it did Proctor any favors. And I think the jury sort of felt for this guy who was having to come in and talk about these really awful text messages. So the next person on the stand was Officer Kelly Dever, and there was a whole dust up about how to pronounce her name. It's Dever. I suppose most people would say Dever, but she pronounces it Dever. She was a Canton police officer, and the night of John O'Keefe's death, she was on night shift on patrol, and she was called in by Sergeant Good to come in and take over dispatch duties to free him up so that he could go to the scene at 34 Fairview. So she's now a Boston police officer. She's been a Boston on the Boston police force for about 2.5 years. Before the first trial, and they didn't call her in the first trial because nobody knew what she was going to say. But before the first trial, she reported, and she was working the dispatch, which is also where all of the screens are for all of the video surveillance within the police department, within the Canton Police Department, including the Sallyport. So not only was she working dispatch, but she also was monitoring all the internal cameras. So before the last trial, she said that she watched Michael Proctor and Chief Berkowitz, who was the Canton police chief and has since died. She watched Michael Proctor and Chief Berkowitz go in and stay in the Sallyport for what she called a wildly long time. So she reported that they were alone in the Sallyport with Karen Reed's car for a wildly long time, just the two of them. Now, Berkowitz and Proctor were good friends. They were close, long-time, close friends. But what happened was, before the first trial, by the time the first trial happened, she had left Canton Police and gone to work for the Boston Force, and she'd been at Boston PD for about a year. She was a rookie. She hadn't been on the Canton Force very long when she moved over to Boston, which does make you wonder, how did she get the job? Did somebody grease the skids for her in return for her for what happened? Because before the first trial, she was called in to the police commissioner's office. Now, Boston is a huge police force. This is like being called into the New York police commissioner's office. A rookie cop doesn't get called into the police commissioner's office. There's probably 5 levels of supervision above that rookie, between that rookie and the police commissioner. It doesn't happen. But she got called in to the police commissioner's office and met with him alone, one-on-one. Now, what she reported came out of that meeting that she would relay was the police commissioner saying to her, "The Boston Force, we're behind you. We're going to back you up. And nudge, nudge, wink, wink, do the right thing." And so she had been interviewed by the FBI. Now, we're in trial number 2, and 2 things that they are dancing around in this trial is that there was a trial number 1 and that the FBI has been involved. So we've heard them say, "Did you testify in a prior proceeding, in a prior hearing? Did you talk to law enforcement who were not the state police and not the Boston police and not the Canton police?" But they've been fairly careful, although Brennan called them agents. And Brennan has repeatedly talked about the first trial, and had let witnesses talk about the first trial. So not really sure it's all that big a secret. But she was interviewed by the FBI, and she told the FBI, no, it wasn't Higgins. It was, according to this officer, it was Proctor. Proctor, who is good friends with, was good friends with Chief Berkowitz, and that it was Proctor and Berkowitz who were in the Sallyport alone with Karen Reed's car for what she characterized as a wildly long time. So she, after her meeting with the police commissioner, but before the last trial, she contacted the FBI and told the FBI the reason that the defense knew about what the police commissioner had said is because they asked her about that. She reported it when she was interviewed by the FBI, and they got it from the FBI. So, but after her meeting with the police commissioner, she contacted the FBI and said, I have now seen video footage, and I now believe that the timeline that couldn't have happened, that I misremembered it, or I had a false memory, is what she kept calling it. It was a false memory because, according to the timeline that I've now seen in the media, it couldn't have happened. So she recanted her testimony, her statements to the FBI as a false memory. She also alleged that when the defense reached out to her and she talked to the defense threatened that they were going to charge her with perjury if she didn't testify as she had earlier testified about seeing Berkowitz and Proctor in the Sallyport. So that's really an outrageous statement. So let me just for those, the uninitiated, I know everybody here is pretty savvy, but just in case. The police investigate a crime, any crime, and they file police reports, and they refer that charging decision to the district attorney. At that point, the district attorney determines whether or not to bring charges. Victims can't drop charges. It's solely within the purview of the district attorney, the Commonwealth, the prosecutor, to make that charging decision, whether or not there is sufficient evidence to charge the crime. Now, the prosecutor could say, I think there's something here, but there's not enough for me to say I can prove this beyond a reasonable doubt. Here you go, police officers, go back and do more investigation. Bring it back to me. Or the prosecutor can say, not enough here, I'm going to decline to charge the case. There is nothing in that equation that is a role for a defense attorney. The only thing a defense attorney could do would be to report it to law enforcement. That's simply, and we all know perjury is very difficult to prove, and it's simply not, that's not the way things work. So for her to say that they had threatened her with perjury, that they were going to charge her with perjury, is just downright silly. The other thing that was interesting about Kelly Dever is she is friends with Sarah Levinson. They went to school together, and Sarah Levinson is one of the people who was in the Albert home at 34 Fairview that night celebrating Brian Jr.'s birthday. Brian Jr. is the 20-something son of Nicole and Brian Albert, the homeowners. And it was his birthday, and he was home, had several friends at home with him, including Sarah Levinson and Julie Nagel. And Sarah Levinson has already testified. So she was, Officer Dever was she was another really difficult witness. She was very testy, particularly with the defense attorneys. But it was clear she wasn't happy to be there either way. The defense, of course, called her, so she wasn't happy at all with them. Hank Brennan did his best to sort of rehabilitate her, but the bottom line is that either it was a false memory or she's decided that the memory was false in order to protect herself and her job. I think the latter is probably more likely. She's a young officer. She's now with the Boston Police Department, and I'm pretty sure that she absolutely does not want to do anything to jeopardize her career. Um, and there's a blue wall. Police officers protect one another. Um, so it is very difficult to say at this point, but the circumstances are very suspicious. It is very unusual for the police commissioner to call in a rookie cop and say, we're right behind you, Kelly, and just do the right thing. So I think it's a little suspect. So the next person was Dr. Marie Russell. Now, Dr. Russell, she is something. Okay. This is a woman who was for 8 years a police officer in California. Oh no, I'm sorry, in Massachusetts. She was working as a police officer at night and going to MIT during the day as a student. Her mother became very ill and was diagnosed with cancer, later passed away. So she left MIT to take care of her mother. She later went back to college and finished all of her pre-med prerequisites and went to medical school. And while she was in medical school, she did residencies both in emergency medicine as well as residencies in anatomical pathology. So not only was she and then in forensic pathology. So not only is she an emergency room doctor, but she also is a forensic pathologist. She's incredibly credentialed and qualified. And one of the areas that of interest to her, both because she is an ER doctor and because she's done extensive work with police agencies and police dogs, she has always been interested in dog bites. And so it turned out that somebody that she knew was following the John O'Keefe case. Now, there is a, a, a theory that John O'Keefe went inside the home at 34 Fairview, that there was some sort of an altercation, and that his body was put back out on the lawn. He was kind of thrown out of the house. The Alberts had a German Shepherd dog who may or may not have been a police dog training washout. I would say it's likely that this dog was a washout from police dog training. Big German Shepherd. She was known to be not friendly, extremely protective over the home, not a dog that that you would let wander around if you had guests in your house. She had bitten neighbors, so she had a history of being aggressive and biting people. And the night that John O'Keefe died, Carrie Russell, who was the other woman who went with Karen Reed to try and find John, along with Jen McCabe, was there, never heard the dog. Jen McCabe then said, Nicole Albert is Jen McCabe's sister. Nicole Albert, Jen McCabe went with Karen Reed looking for John. And when she realized John was on the lawn, she at some point went into the Albert home. And she testified that when she went to wake up her sister and brother-in-law, the dog wasn't there. The dog was nowhere in the house. She walked into the house. Clearly, this dog would have lost its mind if a stranger walked in. Anybody who has dogs is going to say if if a stranger walks in your house, even if it's somebody you know, if somebody walks in your house, that dog's going to alert. This dog clearly was very protective of the Alberts in their home, and if the dog had been in the house, you would have known it. And Jen McCabe testified that the dog wasn't there. She didn't see the dog. She didn't hear the dog. The dog wasn't barking in another part of the house. The dog wasn't barking in the yard. The dog simply wasn't there. So the dog had been there earlier, because in trial number 1, Brian Albert testified that the dog was up in their bedroom, and that he had gone up there to let the dog out the back door or something. So clearly the dog had been there earlier in the evening, but was not there at the time. Now, the defense alleges that the injuries, so when the medical examiner did the autopsy, the only injuries to John O'Keefe were above the neck. He had an injury on his head. He had a scrape on his nose. He had a laceration over one eye, small, and a gash in the back of his head. The only other injury was a small scuff, not even really a scrape, on one knee. So Dr. Russell came in and said, first of all, she's been an ER doctor for 30 years. She's seen countless pedestrian versus auto injuries. And she said it's unheard of for someone to be hit by a car and have no injuries below their neck. People who get hit with a 6,000-pound vehicle have bruises and all those other sorts of things. Now, interestingly enough, Brennan introduced, no, I take that back. The prior medical during their case in chief, he had a medical doctor who came in and talked about the fact that he'd had a case where the person died from a pedestrian versus car impact and had no broken bones. But that doctor put pictures up, including a picture of the victim, and that person had horrible bruising and road rash and injuries to his legs. So he kind of undermined his own case, really. So Dr. Russell said, it's unheard of to have someone have no injuries in the lower extremities when they have come into contact with actually, I think it was the accident reconstruction guy that brought that in to try and say that it's not all that unusual to have that someone can be injured and hit by a car and have no injuries below their neck. So Dr. Russell said that's crazy, that it just doesn't happen. And in a case where you might not have broken bones, but you certainly are going to have bruising and abrasions and all of those things. So the Commonwealth, the only other injury to John O'Keefe, the only injury below the neck, was his arm. And across his arm were these parallel marks across his arm, which they are of the opinion were done by the claws and teeth of a large dog. And so Dr. Russell, who has an interest in dog bites, who has treated many dog bites and was a police officer, as well as treating police officers who trained dogs. And so she's got lots of experience with both civilian dog bites, as she called them, and police canine dog bites. Now, police dogs are trained to bite and hold on. They're trained to clamp on with their jaws, go after them with their paws, and hold on to the perpetrator. And so Dr. Russell looked at the exhibits and opined that she believed that those injuries were created by a large dog. So Brennan went after her. He was very dismissive. He was very insulting at one point. Now, Dr. Russell is, I believe, 70 and recently retired and is doing consulting. And at one point, he looked at her and said, "Do you have memory problems?" And it was just a very dismissive sort of, "You're an old woman, so obviously you can't know what you're talking about." He didn't really do himself any favors, once again with Dr. Russell. And she held her own with him. And he definitely tried to turn her around, confuse her, tried to say things were in reports that weren't. And he wasn't it wasn't the most ethical straight up prosecutor, I can tell you that. So one of the things that the defense walked through why she had her opinions, and then Brennan got the opportunity to cross-examine. One of the things he said to her was, so the first day of her testimony, Brennan kept saying there were things in reports and in transcripts. Didn't you say this? Doesn't this report say that? But he didn't show her the reports. He wasn't using them in the proper way for impeachment. So the next day when he tried that, she said, "Can I see the report? Can I see the transcript?" Well, he immediately said, "Who told you to do that?" And she, who is very upfront and very honest, said, "Mr. Alessi told me to." And so it came out that they have a driver who picks up the out of town people to bring them to court, and that she had ridden in the car with Alessi, and that at one point he had told her she had the right to ask to see transcripts. That's a little bit of a gray area because there is a sequestration order that the witnesses are not allowed to talk to anyone, including the lawyers, until after they're done with their testimony. While they're on the stand and until they are released, they are not allowed to talk to anyone about their testimony. So she said, "I didn't feel like I was talking about my testimony with him, but I didn't feel like it was anything substantive about that." Um, so it ended up sort of being a no harm, no foul sort of situation. He definitely continued to kind of bully her or try to bully her. Frankly, she's she's very educated, very poised, very uh, adept. So he didn't really make much headway at that. But there were a couple of things that came up during her testimony that were juicy and I want to talk about. So one of the things is she said, Brennan said, "So you looked at all these things. You looked at her statements to the media, and you looked at medical reports and all those things." And he asked her, "Did you see any of these film clips of the things that she said in these media interviews?" And Dr. Russell said, "I did see them." And he said, "Well, what didn't she admit, I hit him or whatever?" And Dr. Russell said, I did not take any of those statements seriously because she was clearly suffering from shock and grief. This is the first time that we've had an expert who's come in and said that those questions, did I hit him? Could I have hit him? Were the product of grief and shock. And Dr. Russell went into the mechanism and how that happens very deeply. And I thought it was super effective and very, very important. That is going to be, I mean, that is going to be the building block of their closing arguments. So, excuse me. So the other thing that happened was, and this was a little stranger, a little bit of a more concerning incident. Sorry, had to hit my cough key. Because Brennan asked her whether or not he really got in the weeds with what are these punctures that are in the hoodie, what do they mean? And you know, he really tried to spin her around, and she didn't budge. But at one point he said, do you know that this hoodie was swabbed and that there was no dog DNA on it? Now, Dr. Russell then promptly said, we don't know where that sweatshirt was, for how long. I saw pictures of it on the floor in the hospital. It was rode around in Proctor's car for a while. I'm not entirely sure that anything that you'd get off that would be that reliable. But defense jumps up. Alessi jumps up and says, objection, I want a sidebar. And they send the jury out and they have a very lengthy sidebar. And they come back and Alessi says, Your Honor, I have a motion for the court. And he gets up and he just gives this scorching motion to dismiss with prejudice because the prosecution raised the DNA and they didn't bring it in their case in chief. Now, I think that they probably needed to make that motion. I think that they probably needed to preserve that issue for appeal because I think it's an appellate issue. If Karen Reed is found guilty, they are trying to preserve as many appellate issues as possible. So I believe that they probably had to make that motion. But Alessi was on fire. He was fire and brimstone, pounding the podium. I mean, he was furious. So and he said any mention of the DNA should be kept out, and or the negative DNA tests should be kept out, and I want a mistrial for with prejudice. So the judge said, I'm going to take your motion under advisement and I'm going to think about it. And that was sort of the end of that day's testimony. So Dr. Russell came back in the morning and this morning, and she got on the stand. But prior to that, the judge said, I've considered your motion, I'm denying your motion, and I'm letting in the DNA evidence. I think, first of all, I think that was a wrong decision on her part. But here's maybe a bigger issue. Judge Cannone, we all know that Judge Cannone doesn't like the defense, doesn't like the out-of-town lawyers, the big shots, and has made some very biased rulings in favor of the Commonwealth. And this was just another one of those very biased rulings in favor of the Commonwealth. I wonder if they had simply said to the judge, we want all of that excluded because they didn't bring it in their case in chief. They can't bring in new information in their cross-examination. They just can't. They've got no business doing it, and we want it kept out. And I think they would have had a better argument. I think it was wrong for her to let it in, but she did say he got it in by saying, Dr. Russell, did you see this report? And are you aware that there was in this report, they found no canine DNA? So the judge, I think because she doesn't like the defense attorneys very much and absolutely does not like it when any of them get up and pound on the podium, she just sort of spitefully said, I'm letting it all in. So I think it was a wrong decision, but I think it's possible that if they had not made that fire and brimstone motion for dismissal, which is, it's like going after a fly, and instead of using a fly swatter, you're using a 12 gauge. I mean, it's so, it really is the big gun, and it's not the gun you pull out every day. Now, remember, in the Alec Baldwin trial, they did get a dismissal with prejudice. That was an entirely different circumstance where the prosecution had withheld and actually hidden discovery, hidden evidence. And even at that, their motion was fairly restrained, at least in comparison to Alessi. Alessi was fired up. So I don't. I wonder whether they might have gotten a better result if they had simply said, we want to keep that information out, because they didn't bring it in their case in chief. But it is what it is. And to be honest, I'm not entirely sure it did that much damage. Yeah, there's no dog DNA, but I mean, Dr. Russell simply said, we don't know where that hoodie was. It was, it was certainly not treated. There's not a reliable chain of evidence. It certainly wasn't treated like evidence early on in the case. And we don't have any idea whether there was DNA that was washed off, or we don't know. The other thing is that the actual injuries themselves were not swabbed for canine DNA. Only the hoodie was. So all in all, I think it was probably not all that persuasive, and most of that argument, Alessi's argument, all that stuff was done outside the presence of the jury. So the jury didn't see Alessi coming in hot. All of it was done before the jury came, or after the judge dismissed the jury. So I do think that the jury and everything that we have heard from people who are in the courtroom is sort of interesting about the jury. The jury has been pretty engaged, and there's at least one jury observer who sort of keeps track of who takes notes and who doesn't, and when even the non-note takers are taking notes, that's notable. And the other thing is that the jury is predominantly under 40, which a lot of people feel is going to favor the digital and the computer evidence is going to be more important to them. And probably the digital expert uh, DeSogra, his information is probably going to uh, have more impact. So, and then the last no, not the last witness. We have several more to go. The next witness was Officer Nicholas Barrios. Now, he is one of the officers who ain't got no dog in the fight. He seems like a really nice young man. He was the Dighton police officer. Dighton is another suburb near Canton. And he was the Dighton police officer. Karen Reed's parents lived in Dighton. So John lived in Canton. Karen stayed with him a lot, but didn't live with him. She actually had her own house in another community. But Karen's parents lived in Dighton. So after John O'Keefe's death, she went to her parents, and her car, her Lexus, was parked in their driveway. So when the Massachusetts State Police, Proctor, got a warrant to impound her car, they contacted the Dighton police, it's a courtesy thing, and said, we're going to serve a warrant in your jurisdiction. We want an officer there. So Nicholas Barrows went and was the Dighton officer that stood by while they served the warrant. He said he never went in the house. He talked to not Peggy, Karen Reed's mother at in the garage while he was waiting, while Proctor and I don't remember who the other officer was. I don't think it was Buchanan, were in the house. But he said he saw Karen Reed's car and he stood by and watched while they loaded it onto the tow trailer, the tow truck. And he said the taillight was cracked and there was a piece about the size of a dollar bill missing from it, but the entire taillight was not missing, was not broken out. He testified the same way at the first trial. But the interesting thing was when the prosecution put him on the stand, neither one of them knew exactly what he was going to say. Neither the defense nor the prosecution, obviously, because when he got on the stand and said that taillight was cracked and had a piece missing, but it was not completely gone, then the prosecution decided this time not to call him. So the defense has called him in their case. And so this time they had him look at pictures and compare it to the pictures in the Sallyport, and he was able to say it was not in that same condition when it was loaded onto the flatbed tow truck. Seems like a really nice guy, very believable. Brennan tried to sort of twist him up a little bit, and he didn't go there. He was very clear about what he remembered and what he saw. So the next witness we had was Karina Kolathias, I think is the way that her name is pronounced. Karina Kolathias. She was at the waterfall that night. She and her husband were both called as witnesses in the last trial. She knew Jen McCabe because their kids all played sports together. She's a pharmacist. She had got off work at like 4:30, went to her daughter's basketball game, watched the game, and then went home. When she got home, her husband texted her and said, "Hey, I'm down at the waterfall. I'm going to order some food. Why don't you come down?" She really didn't want to go. She said, "I'm tired. I've had a busy day. I don't really want to go." But he kind of talked her into it. So she got there. She didn't know any of the people. Um, I don't remember how he knew. Maybe he knew John. Because their kids knew each other. I don't remember, but um, she didn't know any of them. She didn't know Higgins, didn't know Alberts, didn't know any of them. The only person she said she knew for sure was Jen McCabe. So she got down there somewhere around 9:30. She didn't want to stay. Her husband said, "Well, I just ordered food, so let me eat my food and then we'll go." And so he ate and they left. But she was there and she did observe that John and Karen were they seemed like a loving couple. At one point, he walked up and gave her a kiss on the forehead, put his arm around her. Um, Karina had a conversation with Karen because John O'Keefe's niece played sports along with the girls. They were all about the same age. And so she had a conversation with Karen. She said Karen was drinking a drink. It was clear. She didn't know what it was. She assumed that it was alcohol, but Karen didn't seem intoxicated. She appeared to hold a conversation. She didn't appear to be intoxicated. She wasn't staggering or any. So um, those were, they weren't fighting, and she didn't see anything that gave her any concern while she was there. So both of those witnesses, and of course the next one, were really good for the defense. I think the defense had a good day today. The witnesses painted a good picture. So their last witness was Lucky Loughran. He is the snowplow driver. Now, what's really interesting about this guy is not only was he the plow driver and did he plow Fairview Road and the roads around Fairview uh, several times during that night because there was a snowstorm. Now, what we know is that the storm started somewhere around midnight and really didn't pick up until early the next morning. Because when John O'Keefe's body was found, there were only about 2 inches of snow on the ground. The weather expert the state put on said there was enough to track a cat, whatever that means. But there was somewhere around 2 inches of snow on the ground when John was found in the yard. Later, nearly a foot of snow fell. So Lucky, as his nickname, Lucky Loughran, he's been a snowplow driver for 20 years. But here's the more interesting part about Lucky. Lucky grew up in Canton. He grew up with the Albert family. He's the same age as Chris Albert, Brian Albert's brother, who is a selectman, which is like city council for Canton. So he's known the Albert family since elementary school. He's known all the Albert boys. He's known the Albert house. As long as he remembers, the Alberts lived in that house on 34 Fairview. Brian Albert actually bought the house or inherited the house from his parents. So um, Brian Albert has lived his whole life in that house at 34 Fairview. So the other thing that's interesting is that Chris Albert, I believe it's Chris, is the one who owns D&E Pizza next to the waterfall. So when John O'Keefe and the whole group came out of the waterfall, Karen wanted them to go over to D&E Pizza because Chris would often open up the pizza place, keep it open, late at night, and they would all have pizza. They would make pizza. So that's what she wanted to do, but they said, "No, no, no, we're all going to the Alberts." So the interesting thing is that Lucky Lochran was a delivery driver for D&E Pizza for about 8 years. And before he went to work for the city of Canton, their public works department. And so he knew the Alberts very well. He worked for D&E Pizza for one of the Albert brothers. He had delivered pizza to 34 Fairview on many occasions. So not only did he know the Albert boys, had grown up with them, knew they lived at 34 Fairview, but had delivered pizza. He said pretty much every Friday night he delivered pizza to 34 Fairview. Knew the house, knew the front door, knew the yard, was very familiar with it. So he goes on shift at about 2:30. He's driving a big snowplow they call Frankentruck, probably because it's put together with as bits and pieces of other rigs. It's huge. They showed pictures, and he showed pictures of it's got big floodlights on the front so he can see what he's doing. It's got great big side mirrors so he can see what he's doing. And it's way up above the usual street level. He sits way high so he can see what he's doing. And so he went to work at 2:30. Snow was starting to accumulate, and they were working on, getting ahead of the storm that was coming in. So the defense attorney puts up a map of the local area, and which is part of his plow route, and he then explains, I went up here and I came down here, and he talks about at what time he plowed 34 Fairview. So he plowed 34 Fairview sometime around 3 o'clock in the morning. He came on shift and started plowing at 2:30. So somewhere between 3 and 3:15, 3:30, he plowed 34 Fairview. He says, I had a view of the yard at 34 Fairview. I could see the front door. I could see the front walk, and there was nothing on the lawn. I know where the flagpole is, and there's nothing on the lawn. So he then goes out, plows the rest of his route, and comes back to make yet another pass on Fairview Drive. This is sometime around between 5 and 5:30, because it is just before law enforcement start showing up. So he plows Fairview. There's nothing in the yard. Oh, one of the passes that he makes, there is a Ford Edge parked in front of the Albert house. It's in the way of him plowing. So typically what would happen is they would try and get the homeowner he would notify his dispatch, and dispatch would contact the homeowner and tell them to move the car. If they didn't move the car, they could be cited and the car could be towed. But Lucky says, I know the Alberts, and they don't usually have a car parked out there. There's usually enough room in their driveway and their garage. That's not typical for there to be a car out there. And he's a cop, and I know them, and professional courtesy, I'm just going to overlook it this time. So he did not report that the car was in the way. He just plowed around it. So, and the Alberts are known to have had at least one, if not more, Ford Edges as family cars. So Tiff just corrected my pronunciation of Colokithis. Anyway, So he plowed. He when he the reason why he knows that the last pass was somewhere around 5 a.m. is because when he came back to make his next pass, the the road was blocked by all the police vehicles because they had already blocked off the road and he couldn't. He had to turn around. So um, he was very clear about his memory of that. Brennan tried to challenge it. He asked him if he remembered that there was a dumpster at a neighbor's house. You know, if you remember what was in their yard, do you remember that there was a dumpster in their house? Well, probably not. But when you realize that there's all this police activity in the yard of a home that you're familiar with and know the people, you know, it sticks in your memory that you know, something happened there. And, you know, it makes you think, boy, did I see something? Well, I didn't see anything. So he was very clear, very unwavering, very trustworthy. Uh, and so I think, I think the jury liked him. Um, uh, Brennan had another moment of being a jerk. Um, he was definitely the a-hole. If you watch on Reddit, there's a whole thread of "Am I the a-hole?" He was definitely the a-hole when he was talking to Lucky and asking him about whether or not he had been paying attention to all the media coverage, and he said, "No, not really." Because it all happened during the time when I lost my wife. And, Brennan just sort of, "Oh, sorry for your loss," but, I mean, he was very condescending about it, and, I don't think it played very well with the jury. I think, first of all, I think Lucky is a pretty engaging, sympathetic kind of a guy. I mean, you know, he's just kind of a salt of the earth guy, and I don't think it played very well with the jury. Um, and that was the last witness today. Followed by, there were some motions that had been filed in the last couple of days. There were a couple of discovery motions, and the the defense renewed their motion to bring in an expert on police procedure. So prior to the case, they had on their witness list an expert who is an expert on proper police procedure. And Brennan filed a motion to exclude that witness, and the judge ordered that witness excluded, saying that they could cross-examine the police and that you know, that police procedures common knowledge, which I thought was a really poor decision. And so they refiled, they asked for reconsideration on the motion to exclude their witness and wanted to bring him in. And they made the arguments that the Commonwealth had opened the door essentially on proper police procedure, and that they had the right to rebut the Commonwealth's contention that there wasn't any that the investigation was perfect and done with integrity, according to Yuri Buchanek. And so they got there this afternoon, and I think it was Yannetti got up to talk to the judge about the motion, and she said, "Oh, well, the only outstanding motion is your motion for reconsideration, and it's denied. Period. No argument, no." So they didn't even get an airing of the arguments. So the judge also, they only went till 1 o'clock today. And the judge also noted that they are not only on schedule, but ahead of schedule. And so decided that since it's supposed to be extremely hot in Boston tomorrow, and that courtroom doesn't have the best air conditioning, and often they have to run fans, and they're loud, and the noise is sometimes hard to hear witnesses over the noise. So she decided that since they're ahead of schedule, that she would give the jury the day off tomorrow. So there is no court tomorrow. I wondered if they were going to come back and argue motions, but she dismissed them summarily out of hand and said everybody gets the day off tomorrow. So, um, and then of course there's Friday, and she likes to get out of court early on Friday. Rumor has it that she has a beach house at the Cape that she likes to get to. So that is Karen Read in a nutshell. Closing arguments start, or opening statements start tomorrow in Vallow case for Brandon Boudreau, and then we'll be wrapping up with Karen Read. Now, to give everybody a heads up, I will not be available next week. I'm going to be out of town. I am doing research on a new project, which I'm not prepared yet to talk about, but I'm super excited about getting this opportunity to do research. So I am going to be gone all next week. So we will reconvene a week from Wednesday. And I'm sure that we'll have the opportunity to talk about Read. Depending on what happens with Read and Vallow, it is possible that we could do a surprise live while I'm gone. So you might want to turn your notifications on just in case. Typically, I wouldn't. I would just hold it till Wednesday, but since we're not going to have a Wednesday live, you might want to make sure your notifications are on. If you have not subscribed to the channel, please do. Please like and subscribe. I think that you can anticipate that there's going to be some changes and some new things coming up. I'm hoping in the fall that we'll have some new things to talk about. So, and I'm excited about the direction things are going in. So, if you haven't yet considered going to CrimeCon, you might want to. It's in September, early September, 5th through the 7th of September in Denver. And it is proving to be a great lineup. I just saw an advertisement that Nate Eaton and Detective Hermosillo are both going to be on the program in a discussion panel on the Vallow case, and I've seen just the inkling beginnings of the lineup. My Vallow book has been nominated for a Clue Award, which is a award that comes from CrimeCon. It's one of they nominate 5 in each category, and they recognize creators in many different categories, podcasters and YouTube. And oh, that's right, I did see Colby is going to be there. Nate Eaton and Colby and Ray Hermosillo are all going to be at CrimeCon this year. Last year, Lori's sister Summer Shiflett was there. So they've got some good guests coming if you're interested in the Vallow case. And there is so much to talk about there. I mean, it's an incredible experience if you haven't been. It gets bigger every year. They get better guests every year, and the creator row gets bigger every year. I mean, the first time I went, there were a handful of creators. Now you could spend all day on Creators Row. I know that a lot of your favorite creators are going to be there. Gigi McKelvey from Pretty Lies and Alibis will be there. I guarantee that Joel Waldman from STS will be there, and Defense Diaries, they'll be there. So it's definitely worth the weekend, and it's a lot of fun. You're going to meet a lot of people. So come on out and we'll meet and have coffee or a glass of wine, and I'd love to meet as many of you as I can. So don't forget that. If the ticket price seems a little steep, don't forget that CrimeCon welcomes volunteers, and that you get a ticket in return for a few hours of volunteering over the weekend. So everybody I've talked to who's volunteered said they still had plenty of time to see everything and hear the panels that they wanted to hear, and that it was a good experience. So you can consider that. As we're ready for questions, we're running a little long tonight, so let's try and answer as many questions as we can, and we'll get underway with that. Thank you, Liz. I think I had heard that Brian Albert's parents built the house at 34 Fairview. That the Albert boys, and I think I counted, they asked Lucky Loughran about them, and he listed all of them. I think I counted 5 or 6. There were 5 or 6 brothers, all boys. I think there was one sister. And so they all grew up in that house, and then Brian Albert and his wife were raising his family in it. After John O'Keefe's death, they renovated part of the house and then sold it, including tearing up the basement concrete. And yeah, so it's been sold. That's right. I forgot to mention that, Charming Frock. Thank you for reminding me. Lucky Loughran's brother is also a Canton selectman. He serves on the select board with Chris Albert. Chris Albert was elected after John O'Keefe's death, but the county select board oversees the Canton Police Department. So Canton is a small town, even though it is sort of in the shadow of Boston, which is huge. It's a small town, and people tend to grow up there and stay. Jen McCabe grew up and stayed. The rest of them, the Alberts, the McCabes, Carrie Russell, they're all long-time Canton residents. So, and a lot of them have known one another since elementary school, middle school. So, other questions? Good question. Hello, eat the food, Tina. Judge Cannoni was appointed. Judges in Massachusetts are appointed. They are not elected. That's a problem. It's a big problem. It was a big problem in South Carolina with the Murdaugh case. It's a big problem. Unfortunately, there seems to be a revolving door, like in South Carolina, where lawyers become selectmen or become legislators, and it's kind of an incestuous process, because lawyers become legislators who sit on the committees who now appoint judges, and it's a lot of quid pro quo and a lot of let me scratch your back and you scratch mine. It's not a good system. I think that states that are still appointing judges rather than electing, I think there are moves in many of those states to change that. I know there is in South Carolina, and I think it should be changed. Judges now, I mean, quite honestly, in Oregon, where I am, judges are elected. However, if a judge ends their term before their retires or resigns before their term ends, the governor appoints their replacement. Then 9 times out of 10, they run unopposed. They're the incumbent, and they run as the incumbent, and they run unopposed. Occasionally, there are contested judicial races. But I think that that's still important because if a judge isn't performing their duties in an unbiased way, there is always the opportunity for a recall, and there's an opportunity for the people to put forth a, a, a a competitor and not reelect the judge, and that isn't a possibility in uh, in Massachusetts. So it's unfortunate. Um, I think that it gives judges an awful lot of power. Um, Judges have a lot of power and a lot of discretion, but an appointed judge doesn't answer to anyone, and that's dangerous. So I hope that will change, but you're right, Tiff. Kerry Russell is an actor and Kerry Roberts is in the Reed trial. You know, you get to be almost 70, and every once in a while, I can't hold them all in my head. Question: how likely is a police officer who has false memories to have much of a career? Well, that depends upon whether or not her false memories help her uh, current situation or not. I find it very suspicious. The whole situation is really suspicious, and we know. You know, I think it's important to remember the the Boston area has had a reputation for police corruption for 100 plus years. This is nothing new. This is no, I mean, this didn't just rear its ugly head. Um, there has been a reputation for rampant corruption in Boston forever. And it's just how business gets done. Um, and it's unfortunate because defendants come out with the on the short end. Um, I mean, in Oregon right now, in my community, the newly elected sheriff, we had a sheriff uh, had an elected sheriff. One of his deputies ran against him, and there was some conversation that the elected sheriff um, retaliated against the deputy because he challenged him. And as a result, the voters voted out the old sheriff and said, you know, you can't treat people like that just because they're your political rivals. But it very quickly came to the attention of the electorate that the newly elected sheriff may not be all that reliable. The district attorney, who I have known probably all my career in Central Oregon, who is absolutely above reproach, stand-up guy, um, put the sheriff, the elected sheriff, on the Brady list. For those of you who don't know, every jurisdiction has a Brady roster, and that is a place where the um, district attorney or judges um, can identify police officers who have proven themselves not to be honest and have lied on under oath. And you don't want to get on the Brady list. So, I mean, it happens in every jurisdiction, and I am concerned that Officer Dever is going to find herself on the Brady list as well. Lying under oath is not something that police officers, their careers survive. So I wonder, um, you know, I mean, is she under the Boston police commissioner's wing? Because I think that's the only thing that's going to save her at this point. Um, Regardless of how she testified. I mean, she can go to court and testify, well, I had a false memory. Well, you know, I mean, any attorney worth their salt is going to say, well, are you lying now or are you lying then? It's kind of like the old, "Have you stopped beating your wife?" You know, you're damned if you do and you're damned if you don't, and that's, I think, where she is. So, I think she's regardless, she has put herself in a tenuous position. There's no question she would have been in a tenuous position anyway. If she'd been called and gone on the stand and said, "Yeah, I saw the police chief and Proctor in the Sally port around Karen's car for a wildly long time," alone and having access to it, then I think that's gonna be a problem too. So, you know, I think it was an unfortunate timing wise, I think it was unfortunate for her that she was there, but, I'm not sure her career is gonna go too far either way. And, that's a product of the overall corruption in the police department. That's not a product of a rookie cop trying to protect herself, I mean, she's sort of between the rock and hard place. So, okay, last question. Anybody got a last question for me? Hi, Sharon. So many law tubers that I follow believe that the Commonwealth has not proven their case. Do you think the jury knows enough about the law to see the case the same way? Well, I think this was a real problem with the mistrial. Um, but we did see in the case, and I have to say that I think the defense has put a stronger case on this time, and we haven't seen the crash daddies yet. We haven't seen the accident reconstruction guys yet. But I think overall, the defense has put forth a more organized and stronger defense. And I'm not sure that the Commonwealth has put on any stronger a case this time than last time. So, um, and we saw last time it was enough to get a hung jury. Um, I don't know if it is going to be possible to get outright not guilty verdict. Um, I don't know. I would hope that the defense is going to really hammer home in their closing. There was no collision. They can't prove a collision. That's reasonable doubt. And really hammer the reasonable doubt piece. I'm not sure they did as good a job of that last time. I hate the fact that this judge is limiting the time that they can spend on their closing, and they're having to pick and choose what to really focus on. I don't like that. And I think an hour for a case that's gone nearly a month is terrible. It's wrong. But that's what they're stuck with. So they're having to sort of pick and choose among their arguments and their evidence and try and bring forward the strongest arguments. So um, I think that if you stack up the accident reconstructionists, Dr. Russell, and the coroner not being able to call this a homicide. Now, there are a couple of other experts that I hope we're going to see when the medical examiner, Dr. Scortibello, and she did not do the Commonwealth any favors in her testimony. She actually did the defense quite a few favors. But one of the things she testified to was that when she realized that the cause of John O'Keefe's death likely was a head injury, she then sent John O'Keefe's brain to a forensic a forensic neurologist, someone who is an expert on brain injuries and assessing forensically assessing brain injuries. So she testified that the brain is the brain is very gelatinous. I mean, you could stick your finger through it. So it had to be processed, it had to be preserved so that it would solidify to the point where it could be analyzed. And it was sent to this forensic pathologist. And she testified at the last hearing. She was the one who, she's young, she's very qualified. It was very hot. She came in a sundress, and she has a whole sleeve of tattoos. Of course, that, you know. Um, there were some people who were like, "Yeah, she should have, dressed a little more professionally and blah, blah, blah." But she was incredibly qualified. I think we're gonna see her again. We're gonna see her come in and talk about, the effect, that an injury of that kind would cause. And certainly we're going to see the accident reconstructionist. Now, there are things that we didn't hear last time that I think we are going to hear this time, and that is that, in the last trial, when the ARCA experts testified, Judge Cannoni ruled that they could not opine, uh, on whether or not the injuries were John O'Keefe's death was caused by a car, because they were not medical. They were not medical doctors. This time, she let that testimony in from the prosecution, so I think she's going to have to let it in with the crash daddies. So there is going to be that piece. I think Dr. Russell did them a huge favor in raising the issue and completely taking the wind out of Brennan's sails when it comes to all those media interview clips, and all of this, I hit him, I hit him testimony from Jennifer McCabe. She just sucked the wind right out of those by saying, I'd completely discounted them. I'm an ER physician. I have dealt with hundreds and thousands of families in the midst of trauma and crisis, when a loved one has been injured or killed. And I completely discounted that because she was in the midst of grief and hysteria. And I thought that she did them a huge favor with that. So I think they probably have a couple more days. I think they may have a few more witnesses. The crash daddies maybe Monday, and then I think we're going to see closings. So we could see the defense rest sometime midweek, maybe even. So I mean, there's not that much more that the defense has got to bring in. So. Um, So we will see. We could have Vallow and Reed both wrap up, of course, while I'm out of town. So watch your notifications. One last question, and we'll wrap it up for the night. Was she not friendly, or did Brian Albert teach her to attack and be aggressive? Oh, the dog. Well, I think, first of all, if my presumption is right, and she was a washed out police dog, when they are looking for a police dog, they're looking for dogs of a particular temperament. They're not necessarily friendly family pets. They are they are screening dogs for a particular temperament, for dogs that don't give up, dogs that can be trained to hang on, so if, as I speculate and we suspect, Chloe, whose name is now Cora, I think, um, if she's even still out there, if she was in fact police dog trainee that washed out. She was selected for that temperament to begin with. We know that she was not a friendly dog. We know that she was responsible for biting neighbors, that that a neighbor ended up in the hospital because of the dog. We know that she was not a dog that anybody would probably feel safe and confident around. She wasn't a trustworthy dog. Now, I don't know whether Brian Albert taught her or encouraged that underlying training and behavior, but you have to assume that she had that temperament to begin with, because that's the way they screened those dogs. Now, that doesn't mean to say that police dogs can't be great family pets. I mean, we had a family friend who was a canine officer, and his canine partner retired and was just a big old friendly big lug of a German Shepherd. But they're not all that way. And they are definitely selected for a particular temperament. So I don't really know whether she had underlying training and he encouraged it, or whether that was just her temperament. I'm losing my headphones here. So, and I don't know that we're going to find out. I mean, unless the defense knows more than we think they do. We know that Buchanan went to find the dog, and but they didn't really document who her current owners were, and it appears that she's been through 2 or 3 owners since the Alberts rehomed her. So, you know, that sort of gives you a clue that this is a problem dog. And the testimony was that the current owner, if she's still out there, is a vet, and that it was sort of like only a vet could contend with her. So, and also she wasn't young. I think the Alberts said they'd had her 6 years. We know that large dogs, particularly German Shepherds, don't have great long lifespans. So by now she could be 8 or 9, and that she could be really at the end of her life. So it's hard to say. The state has this rebuttal witness that they want to bring on, who's the dog bite expert, who's not a doctor and not a vet and nobody knows quite what he is other than a dog trainer. So we're not quite sure. He might turn up in their rebuttal arguments to rebut Dr. Russell's testimony. Not that I think he's going to be able to do it, but we'll see. Well, everyone, thank you so much for joining me tonight. I never lose sight of the fact that there are many other things you could do with your Wednesday night, and I always appreciate when you have so many people. I love our chat. I love how collaborative everybody is. I love that that this is a chat where people can feel safe to exchange their opinions without feeling like they're going to get ganged up on. So I appreciate you all being here. Have a wonderful next 2 weeks. If we get verdict, it may very well be that I'll see you for a surprise live. But until then, have a great week. Thank you so much, Jennifer, for always being the moderator with the mostest. And we'll see you in a couple of weeks. Good night.